Here we're talking about redundancy. Redundancy is when an employer decides that an employee's job is no longer required through some sort of business change, strategic planning change, or some sort of financial change. It can happen really quickly, or it can be over a period of time. Sometimes redundancies occur when a business sells and a new owner decides that they're not going to take on all the employees from the old business. Okay, so what is redundancy? Redundancy is when an employee's job is no longer required. If you've been made redundant, the likelihood is that you've been told at some point that your job may be made redundant, and then you've been told that your job is actually redundant. Like I said, this can happen over a period of time, or it can happen really, really quickly. Now, one of the questions I get asked a lot from people like yourself is, what is a genuine redundancy? Now, a genuine redundancy is, and if we just go to the Fair Work Act here, and it's essentially a person's dismissal is a case of genuine redundancy if the person's employer no longer requires that person's job to be performed by anyone because of a change in operational requirements, and the employer has complied with any obligation in a modern award or enterprise agreement. Now, there is an exception here. It is not a case of genuine redundancy if it would have been reasonable in all the circumstances for that person to have been redeployed in the business or an associated business of the employer. So when we think about redundancy, we think about what's happened. We think about what's been told to you by the employer, and we look at the documents as well. So we go back to the employment contract, we have a look at these, and you think about redundancy in there. If you fall under an award or an enterprise agreement, then we need to look at the consultation requirements about redundancy in those as well. Now, there is a question that also gets asked a lot about what are entitlements in redundancy. This is actually a bit of a complicated question, because redundancy what you're entitled to in terms of redundancy depends on how long you've been with the employer for. It depends on the size of the employer, whether they've got more than 14 employees or less than 14 employees, and that number also gets calculated with the associated entities. It also depends on whether you are a permanent employee or a casual, or whether you're a contract worker and your contract's coming to an end and they've decided not to replace that particular job in the business. So let's talk about contract workers for a start, because that's actually a really simple answer. If your contract is coming to an end, and they're choosing not to renew it, your employer's choosing not to renew it, or if your contract's coming to an end and your employer's decided that they don't want that job in the business anymore, then it's more than likely you're not going to be entitled to redundancy. This is because if your contract's coming to an end, there's a natural end to that job of yours. But if you've been working there for some time and you've had multiple renewals of that contract, then there's a far more complicated answer there, and I'm not going to be able to provide you that advice today, right now, but it's definitely something you should probably look into. If you've got a permanent employment contract, if you're a part-time employee or you're a full-time employee and you've been working for the business for more than a year, then there's a possibility you're going to be entitled to what we call a redundancy payout. Those redundancy payouts get larger as you work more. For instance, if you've been working there, and I'm just going to turn to the Act, if you've been working there for at least a year but not less than 2 years, then you're going to be entitled to 4 weeks redundancy. And it goes up on a scale. If you've been there for 5 years but less than 6, you're going to be entitled to 10 weeks redundancy. But then it gets a little bit more complicated. At 9 years but less than 10, you're going to be entitled to 16 weeks redundancy. But after 10 years, you're only going to be entitled to 12 weeks redundancy. Now, I'm basing this on the National Employment Standards. There might be something different in your employer's policies and procedures in relation to redundancy, in an enterprise agreement related to redundancy, or some other document like your employment contract that relates to redundancy. The reason why employees who've been with an employer for more than 10 years are entitled to less money than an employee that's been there for 9 years, for example, that's 16 versus 10 weeks, 12 weeks amount, is actually your long service leave. After 10 years, you've had your entitlement to long service leave crystallise, and you're entitled to more long service leave at that point. But conversely, if you are been with your employer for more than 7, especially in Queensland, where I'm basing this particular information from, in the state of Queensland, long service leave is regulated by the Industrial Relations Act of Queensland 2016. That says that if you've been with your employer for more than 7 years but less than 10, if you're made redundant, then it is more than likely you're going to be entitled to a pro rata amount of your long service leave. So that's really good news for people in Queensland. Now, depending on different states, has different rules, and the amount of long service leave also changes state to state. Consider whether you're under an award or an agreement. Okay, so I keep saying that it depends on whether what's in your employment contract, what's in your award, what's in your enterprise agreement when it comes to redundancy pay. This is because your employment contract might actually stipulate how much money you're entitled to in relation to redundancy. An award will also provide you some assistance there, but I can tell you that most awards will say something like you need to consult with your employee, and that lends us back to whether a redundancy is genuine or not. If your employer hasn't consulted, then it's possibility that your redundancy is not genuine, and you might have some recourse there. And if you're under an enterprise agreement, it is more than likely there are consultation requirements in your enterprise agreement in relation to your redundancy as well. Now, also, your enterprise agreement might stipulate how much redundancy you're entitled to, and that can change as well. But as a general rule, it is more likely than not going to be less than your NES entitlements, that National Employment Standard entitlement. If there is something in your enterprise agreement about what you're entitled to, there is a good chance that you're going to be entitled to more redundancy. I hope that helps you today. If you need any more help on this, let us know and we'll be able to give you some more advice. Thanks for watching.